You heard some of what went on today in our conference. The judge adjourned it, I believe, to March 12th. That's a control date with an eye towards having this hearing at some point. What's important to note is we are waiting for a lot of discovery just on this very issue. Remember, this is a FRI hearing, so this is novel information. They call it science. We're disputing that. So we're looking forward to getting things that we are entitled to in order to prepare and conduct this FRI hearing. So we've been on this for a year and a half. Astrea on the West Coast has been on this well before that, and we're still waiting for significant portions of discovery that we're entitled to before we even get to the hearing. So that's why we made that demand. The prosecutor today responded in a letter form saying, we're going to give you much of what you asked for that you haven't received yet. So we'll sit back and wait for those items. And just to give you what the prosecutor indicated to us in terms of the magnitude, I think they said that they were downloading this onto some hard drive that costs roughly $1,100, $1,200, and they've been doing this for probably 7 or 8 days. Not the DA's office, but Astrea on the West Coast. 24/7 with these high-powered computers, and they're only at 40%. So the other 60%, maybe it will come in another week or so. That's roughly 2 weeks of constant download. And then they have to give that to us, and then our experts have the right to prepare, and we can consult with them, and at some point in the future, hopefully we can go forward with the FRI hearing. The other issue is we also made a motion to sever or separate certain counts in the indictment. The prosecutor today submitted their opposition in regards to our motion. We've asked the court to have the opportunity to reply to their opposition, and he gave us until March 12th, and hopefully by then we can have a reply. I'll leave it at that.
Like, why do you want to separate the cases?
Well, did you have an opportunity to look at the motion? You may not.
Yeah,
You
I
have?
just want you to articulate.
Sure.
Please.
You know, you have different victims and different evidence. And concededly, some of the evidence and some of the victims should be tried together. We've conceded that in the motion. Many of the other victims should not be tried together. They have nothing to do with each other in the sense of the location of where the bodies were found, the type of murder that was committed, the evidence that they have. But in essence, what the prosecutor is doing is they throw everything into the grand jury, and they try to throw as much into it and then bring it before a jury, because there's the old adage, when there's smoke, there's fire. And that's something, obviously, as a defense attorney, we have to fight. But they have no business, meaning some of those counts, to be tried at the same time. Because at the end of the day, he's presumed innocent on each and every count, and he has an absolute right to have a jury consider the evidence as to those counts. So it would prejudice the jury if they heard other evidence that's unrelated. So that's why we make the motion to sever.
Is your client being made aware of the delays in the actual trial that are being necessitated by the requests that were being made by his counsel?
Yeah, well, when you...
He's in jail.
The answer to your question is yes. He's aware of any time we delay the case. We speak on a weekly basis. So he knows the progress of the case or lack thereof. He knows where we're at. And he too doesn't want it rushed in the sense that although he wants to get before a jury as quick as possible, he also understands the complexities involved, especially regarding this DNA. The DNA is so important to this case because you have to remember that's really what the prosecutor is hanging their hat on. So this isolated hair, one hair per body, and keep in mind there are numerous hairs on each body. But the one hair that they claim comes back to either my client or his former wife. This is a company on the West Coast called Astrea. They are not permitted here in New York. They're not certified to perform this in New York. They are not a forensic lab in New York. I don't even think they're a forensic lab on the West Coast. And what they've done is, and I've reviewed to the extent that a layperson can, but I've used the experts, they are so different than a forensic lab. For instance, the Suffolk County Crime Lab. That's one example of a forensic lab. They're a research organization, and you can see, even when they're doing their analysis, if they don't like where they've gotten and what the result is, they pivot and they try it another way. That's not a forensic-oriented lab. Forensic labs have protocols, they have procedures, and they follow it through. And if they can't get to that point, they stop work. That's not what the West Coast people do. This is a for-profit company. They stand to make a lot of money if this is accepted in the state of New York. There's no state in the nation that has accepted what they claim is science, with the exception of Idaho. And in Idaho, their standard for accepting this is extremely low. So going back to your question, he's being patient because this is so important.
Mr. Brown.
What the 14 points are? I mean, it's the stuff that.
There's a lot of different things. There's validation studies, which as a forensic lab you have to have and maintain and turn over. There's protocol. There's the raw data. There's scientific analysis. There's also the actual program that this Astrea has utilized to come out with their statistics. And I can tell you that our expert, who will testify, has indicated that the statistical analysis is extremely faulty and defective. So what it does is, it takes what could ordinarily be a 1 in 1,000 likelihood and takes it off the chart. So that's what we're deliberating, and that's what this Fry hearing is about. And again, this is not science, or their methodology has not been accepted in this state or any other state with the exception of Idaho. It's not even accepted in their home state of California.
And Mr. Brown, you just said Rex's former wife. Has Rex and Asa's divorce been finalized at this point?
I was referring to his first wife.
Okay.
And I think that's your question, right? And I don't know the status. I don't know the status.
Thank you.
How is he
Any-
doing?
I'm sorry?
How is Fluently doing? Rex. How is Rex Fluently doing?
He has maintained his innocence from there. He has said, I'm not guilty of these charges. And the more I review, the more I inspect what the prosecutor has, it leads me to believe that he's not the guy. But he's holding up okay. He's looking forward to having his day in court. And we'll get there. We will. It's been a long road. It's a year and a half already. But every time we turn a corner, or what I think we turn a corner, we get bombarded by new documentation, new discovery, new allegations. I know we'll get to that point sooner or later. And I'm looking forward, I really am. And one of the reasons we did not file a change of venue motion is because we are looking forward to 12 people in Suffolk County, the residents in Suffolk County who are familiar with what goes on in Suffolk County. We are looking forward to having them sit in that courtroom and listen to the evidence and listen to the lack of evidence, listen to the whole picture as opposed to just snippets that you may have heard. Looking forward to that.
So you ruled out the change of venue?
We have. We're not doing a change of venue. There's nobody better, in our opinion, and I've been doing this for 30 years, there's nobody better situated to listen to this case and listen to the rules of evidence and the evidence than 12 people in Suffolk County.
Why is that?
That's what I believe. I have faith in the people in Suffolk County. They know the history of the police department. They know the history of this investigation. We can go through bit by bit, piece by piece. We'll save that for trial. The DNA is really, go back to the DNA, how they're hanging their hat on it. The government has said from day one that they have this kill room in my client's house. That's where everything went down. His wife and family were away, and all the things went down in his basement. There is not one shred of biological forensic evidence that's in his basement. Not one. Nothing from the victim, nothing from him. So what, in essence, you're telling me that you have a 1 hair per person, per victim. He wasn't conscientious enough or careful enough to make sure that didn't happen, but yet the basement is completely scrubbed. It doesn't make sense.
Actually, doesn't the fact that there's no DNA from him, his own basement, is not a little, strange? I mean, I don't think we go into any of our basements and find no
I don't mean no
DNA.
DNA from him. I misspoke.
Okay.
I'm talking about the victims.
Okay. And you also use the word scrubbed, you're saying that the basement was completely clean of any DNA and it was scrubbed. That's kind of like the opposite of
No,
what
I'm
you would
not.
want to say. Right?
I'm not, no. My point is, how do you explain that there is nothing in the basement if that's the killer. It doesn't make any sense. If that actually transpired and he's the perpetrator, you would have to expect that there would be some remnants in the basement. And my point is, what I'm trying to say with the word scrub, even if he's sitting there scrubbing, you're not going to eliminate each piece of evidence. So it leads me to conclude and suggest that it didn't happen that way and he's not the perpetrator. That was my point.
Thank you.
All right, we're good?